December 1965. The United States was plunging deeper into the Vietnam War. This is the story of Mary Beth Tinker and a black armband. It's a story about what it means to have a voice, the limits of authority, and how a quiet act of defiance in a school hallway forever changed the landscape of free speech for students across America. The plan was simple, and in the students' minds, entirely peaceful. Organized by local anti-war activists, a group of students from Des Moines, including 13-year-old Mary Beth Tinker, her older brother John, and their friend Christopher Eckhart, decided to wear black armbands to school. The armbands were meant to mourn the dead on both sides of the Vietnam War and to show support for a Christmas truce proposed by Senator Robert F. Kennedy. It was a silent, symbolic protest. They had no intention of disrupting classes or causing any trouble. Mary Beth Tinker recalls the atmosphere of the time. The war was everywhere. It was on the news every night. Young men from their community were being drafted, and some were not coming back. For Mary Beth and her friends, the war wasn't just a political issue, it was deeply personal. They felt a moral obligation to speak out against the violence and advocate for peace. The armband felt like the only way they could do that, a quiet plea for an end to the bloodshed. But the school administrators in Des Moines saw things differently. Hearing rumors of the planned protest, the principals of the local high schools met on December 14th and adopted a new policy. Any student wearing an armband to school would be asked to remove it immediately. If the student refused, they would be suspended until they agreed to return without it. The school board argued that the armbands could be disruptive, potentially leading to arguments or even violence between students who supported the war and those who opposed it. On December 16th, Mary Beth Tinker and Christopher Eckhart wore their black armbands to their respective schools. Just as the principals had warned, they were told to remove them. When they refused, they were sent home, suspended. A few days later, John Tinker did the same and met the same fate. The students hadn't shouted, they hadn't held up signs, they hadn't interrupted a single lesson. They had simply worn a piece of black cloth on their sleeves. Yet, they were punished for it. The school district stood firm. Their position was that they had a responsibility to maintain order and a disciplined educational environment. They feared that allowing this one political symbol would open the floodgates to others, turning school hallways into battlegrounds for political debate. In their view, the school was no place for such displays. But for the Tinker family and the American Civil Liberties Union, which quickly took up their case, this wasn't about discipline. It was about a fundamental constitutional right. Did students leave their First Amendment rights at the schoolhouse gate? That was the question at the heart of the legal battle that was about to begin. The students' fathers, with the help of the ACLU, filed a lawsuit in the U.S. District Court. They argued that the school district's policy violated the students' right to free speech. The district court, however, sided with the school officials. The court ruled that the armbands could have been disruptive, and the school's need to maintain order outweighed the students' speech rights. Disappointed but not defeated, the Tinkers appealed. The case went to the U.S. Court of Appeals for the 8th Circuit, but the judges there were split, resulting in a tie. This meant the lower court's decision stood. For Mary Beth and the others, it seemed like every door was closing. The legal system seemed to agree with the school. Students should be seen and not heard, especially when their views were unpopular or controversial. But the fight was far from over. The ACLU decided to take the case to the highest court in the land, the Supreme Court of the United States. In 1968, the court agreed to hear Tinker v. Des Moines Independent Community School District Star. The stage was now set for a landmark decision. The case attracted national attention. It was no longer just about a few students in Iowa. It was about the rights of millions of students across the country. The oral arguments before the Supreme Court were tense. The lawyer for the school district argued that schools were special environments where administrators needed broad authority to prevent potential disruptions. He painted a picture of chaos, suggesting that if the court sided with the students, schools would become forums for constant political protest. Dan Johnston, the young ACLU lawyer representing the students, presented a powerful counterargument. He emphasized the silent, non-disruptive nature of the protest. He pointed out that the school allowed students to wear other types of symbols, like political buttons for presidential campaigns or even the Iron Cross, a symbol of Nazism. Why, he asked, was a simple black armband treated differently? He argued that the school's fear of disruption was purely speculative. There had been no actual disturbance, no fights, no shouting. The school had punished the students not for what they did, but for what the administration feared they might do. On February 24, 1969, the Supreme Court delivered its momentous 7-2 decision. Writing for the majority, Justice Abe Fortas penned one of the most famous lines in constitutional law history. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court made it clear that student expression is constitutionally protected. For a school to justify suppressing speech, it must show that the student's conduct would materially and substantially interfere with the operation of the school or invade the rights of others. The mere fear or apprehension of a disturbance is not enough. In the Tinkers case, the court found no evidence of any actual disruption. The student's silent protest was a form of pure speech entirely separate from any disruptive action. The Tinker decision was a monumental victory for student rights. It established what is now known as the Tinker test, the legal standard that courts use to this day to determine when a school's censorship of student speech is constitutional. The ruling affirmed that students are persons under the Constitution, with rights that the state must respect. It championed the idea that schools should be marketplaces of ideas, where students can learn to engage with different viewpoints and participate in our democracy. But the story doesn't end in 1969. The legacy of Tinker v. Des Moines is complex and continues to evolve. In the decades since, the Supreme Court has revisited the issue of student speech, sometimes narrowing the protections established in Tinker Star. Cases involving vulgar or lewd speech, school-sponsored publications, and off-campus online speech have created new challenges and legal grey areas. For example, in Bethel School District v. Fraser in 1986, the court ruled that a school could punish a student for a sexually suggestive speech at a school assembly. In Hazelwood v. Kuhlmeier in 1988, it held that schools have greater authority to censor school-sponsored speech, like a student newspaper. These decisions chipped away at the broad protections of Tinker, giving schools more leeway to regulate student expression under certain circumstances. More recently, the rise of the internet and social media has presented entirely new questions. Can a school punish a student for something they post on their personal social media account outside of school hours? The Supreme Court tackled this question in 2021 in Mahanoy Area School District VB.L. siding with a cheerleader who had been suspended for a profane Snapchat post. The court affirmed that schools have a diminished interest in regulating off-campus speech, reinforcing the core principles of Tinker for a new digital generation. Her story serves as a powerful reminder that even the youngest and quietest among us can make a profound impact. The Tinker case remains the bedrock of student free speech law in the United States. It stands for a powerful and hopeful idea that public schools should not be enclaves of totalitarianism. While the line between protected speech and punishable disruption is constantly being debated and redrawn, the core message of Tinker v. Des Moines endures. Students do not leave their rights behind when they walk through the schoolhouse gates. Their voices matter. And sometimes, the most powerful statements are the ones made without saying a single word. Thanks for watching. If you found this story inspiring, please like this video and subscribe to our channel for more deep dives into the history that shapes our world today. Let us know in the comments, what does student free speech mean to you?